Good evening. Thank you for that generous introduction from the Deputy Prime Minister, and it's been a pleasure to meet his wife as well. And thank you also to Sir John Graham, who is so delightful to speak with, and the representative from the New Zealand Law Foundation. I haven't met a person from Clavel Capital yet, but I'm sure you're equally charming. Thank you all for having me, and Alex and the Maxim Institute. It's an honor to be asked to come so far to address you. I'm grateful to you for coming and for the conversation that I know we'll have. I've really enjoyed reading and thinking about New Zealand's law and culture. And of course, I will tell you that I learned a few things years ago as the mother of a rugby-playing son who knows enough to bow down before a country that does that right. We were up against a team where the coach was a bona fide New Zealander, and we were terrified, and we had our shirts handed to us, I will tell you that. So I bow down there. We just wear the all-black stuff and just, go with that. Our countries and our cultures do differ significantly, but there's a lot we can talk about when it comes to the role of conscience protection in a free, diverse, and pluralistic society, which both of us enjoy in our countries. And of course, in a shrinking globe, we're now facing very similar dilemmas respecting freedom of conscience, whether we're talking about rights respecting life and death, sex, religious garb, education, or military conscription. For example, on this last matter, both of our countries have reflected. In the US, the inquiry was twofold. Number one, we asked, could philosophical objections count, as did religious objections? We answered yes. There was also the question of how far removed from actual, behavior as a soldier could your objection be to count? And in the US, we said it could be pretty far removed. You could refuse even to participate in any part of the manufacture of the equipment that would be used in war. Here in New Zealand, you have a different history. You're likely familiar with the story of some of your conscientious objectors at the beginning of the 20th century, which I believe was pretty recently dramatized in a television program named after some of the punishment those soldiers who conscientiously objected were subjected to, field punishment number 1. In New Zealand, therefore, some of these conscientious objections were rejected. Objectors were sometimes imprisoned, and some subjected to what could really only be called torture. Dramatic interests were asserted on both sides. On the one side, avoiding participating in harming or killing other human beings. On the other side, requiring people to defend some human beings against the lethal aggression of others. What is the framework for evaluating competing claims like this? So this is just one example of the clash of rights that any country can experience when conscientious objection is asserted. So at the beginning of my legal career, I actually sought out a law firm because it handled such cases for a wide variety of religions in Philadelphia. In fact, the firm was founded, it turned out, by 4 Catholic guys, and in Philadelphia, you couldn't get a job as a lawyer as a Catholic in the 1920s. And so they founded a firm because they couldn't find a job. And then they became a religious freedom firm based on that experience. Then I worked on this issue for a church. And now I teach respecting these matters at a truly secular state university in Virginia with a wide variety of students of every faith and no faith, and this is also true of the faculty. So I hope that this experience that I've had now, which is, I'm shocked to tell myself, is now 30 years old, worth of experience, can be put at your service today. So I would start by saying that there appears to be a general agreement in our cultures that cultures like ours favor respect for individual conscience. In fact, it's a mark of pride we share that we don't squash the human spirit. But there's also no doubt that that commitment gets a bit fraught when the subject turns from beliefs to practices, especially if the practice is not very well understood or it's lesser known, or when the conversation turns to protecting conscientious objection in the context of a really popular or very stridently defended law, or a law advertised as righting a historic wrong, or when there's a background worry about unleashing chaos if a lot of conscious protection is allowed in a diverse society. There's a lot more here than one presentation could tackle, so what I'm going to do this evening is I hope to provide a framework for you to think about these cases when they hit the headlines. And then I will try to show you how this framework might address a particular instance which has to do with facilitating access to euthanasia. I'm going to do this in 3 parts. First, I'm going to suggest why there's a notable increase in conflicts between conscience and other asserted goods or rights today. And I'll tell you, if you start from this situation, you'll see that the clash is not really solely driven at all by people's discomfort with religion generally or particular religions. There's a variety of factors, some very mundane, that are acting to pressure conscience. And if you begin by thinking this way, it can ease tensions and avoid some of the difficulties that are inherent in the very complex question of exactly how much room for conscience should a particular society allow. Second, I'm going to suggest why I believe respecting freedom of conscience is an individual and a social good, why it's good for society. Third, I want to suggest how the principles I've proposed could inform deliberations in connection, for example, with the End-of-Life Choices Bill here in New Zealand. So, turning to the first part, the reasons why there's a notable increase in these conflicts today. There's at least 4 reasons I want to suggest here. One, everybody knows we're both in the US and the data I think indicates in New Zealand an increasingly regulated society, particularly in the last several decades. And those regulations are affecting more areas of life, areas once governed by private choice, including private conscientious beliefs, including religious beliefs. And then some religious beliefs led people to found charitable or other kinds of institutions, which are now also subject to more regulation. Add to this the fact of increasingly diverse societies. That's certainly true here, it's certainly true in the United States, where people of many religious or spiritual or philosophical beliefs, as well as people who subscribe to none, rub shoulders more often in their personal and work lives. There are simply bound to be more differences of opinion about what behavior ought to be required or permitted. And then this can give rise to a kind of generalized anxiety about preserving peace before clashes arise. In fact, when our US Supreme Court kind of spelled out what I just said to you in the 1990 decision about whether we would allow certain Native American tribes to use an illegal drug, peyote, in their religious worship, they mentioned the word anarchy to describe the difficulty of allowing so many exemptions in a diverse society. So added to this, then, the fact of more regulations in diverse society is the fact that more modern regulation has the character of requiring cooperation with a particular act. We're not just talking about laws allowing other people to do things that you or I don't like, but laws forcing conscientious objectors to act against their conscience. This feels a lot more intrusive to people. Add to this the fact that more regulation is now touching more fraught matters: religion, sex, the family, education of children, life and death, the social status of women, the status of groups historically subject to marginalization. Oh my, I mean, these are very fraught areas. Then add to this the fact that many regulations are adopting moral views which are frankly just a couple years old in some cases, or maybe a couple decades old, as compared with the fact that prior conscientious or religious commitments were widely shared by the population and the government together. And when we're talking about religious communities, these were ideas that religious citizens held maybe for thousands of years in their religious tradition. So it feels to many citizens that in some areas, the law turned upside down, abruptly started knocking on their doors, and made particular demands of them. Further, these citizens are then told that when they refuse to go along, it is they who are imposing their worldview on others, when they frankly feel that it's the other way around. Add to this that because of the more privileged educational or socioeconomic positions of the people in positions of public and private authority, whether we're talking the government or media or entertainment industry or the academy, more socioeconomically typical citizens feel that the regulations that are being brought to bear on their conscience don't incorporate their values. So that adds another layer of controversy. A textbook example of this clash happened recently in the United States in a case that you may have heard of in the news called the Hobby Lobby decision, kind of a funny name. The owners of a big chain of craft stores, the Hobby Lobby stores, claimed that they could not cooperate with the federal requirement to provide for their employees and their daughters. And by the way, some of these were minor daughters, and the government said they were going to educate the daughters specifically, directly, without the parents' involvement. This was going to provide health insurance for free drugs and devices that the federal government admitted in its documents, and the Food and Drug Administration has admitted for a long time, could destroy human embryos, okay? So this was certain kinds of morning after pills, they call them, or IUDs. This law contradicted decades of US law, which had given pretty generous exemptions to conscientious objectors where abortion was concerned. This new law contradicted popular will, and interestingly, the people most opposed to this new law in the United States were women and people with less money and less education. It involved forced cooperation with an activity, and of course it involved the weighty matter of the life or death of a human embryo. The federal government additionally stoked controversy by arguing all the way up the chain of courts to the Supreme Court that it was up to the government to decide what behavior violates individual or group consciences, that individuals and groups did not have the right to decide that for themselves. Now, our Supreme Court very recently granted victory to the business owners. But they granted them victory only as a closely held corporation. They didn't claim to know what larger corporations would or would not get in the future in the way of conscience protection. The Supreme Court was particularly firm on the conclusion that religious actors get to decide for themselves what violates their conscience within reason. There has to be some relationship to their religious belief, and it has to be sincerely held. But the court was not particularly strong on the matter of shielding conscientious objectors from possibly some forms of cooperation with abortion in the future. So, that's the whole description of the increased regulatory state as one possible reason for more conflicts now. A second reason, I think, would be some notable aspects of the modern human rights consciousness. And I want to highlight three of these. First, there is a modern focus upon the notion of equality as a particularly important part of human rights. It's more pronounced today, maybe. We seem to have woken up, not perfectly, but better than we have in the past, I think, to the human rights claims of large groups of people who have been denied equality. When, therefore, these particular groups assert that the mandate of equality requires this or that particular law or rule, any opposition to that rule, even conscience-based, is easily and readily construed as human rights denying. Okay? A second aspect of this modern human rights consciousness, and this is very pronounced in the United States, specifically even out of the mouth of our Supreme Court, is that we have come to identify a person's sexual inclination and sexual expression, sexual acts that they wish to do, with that person's whole identity. So therefore, to suggest that any consensual sexual expression should not get state support, recognition, even a status recognition, to suggest that it should not is now easily labeled as opposition to fellow citizens' identity or personhood. Conscientious objectors believe that they're only taking a position about certain acts or behavior or government-recognized status. They don't think they're denying personhood or dignity. They think that they are opposing the states forcing them to go along with certain acts. But that's not how their conscientious objection is interpreted. A third and final aspect of the modern human rights consciousness is a tendency to seek identical outcomes for men and women as the imperative of equality and freedom for women. So in particular, in the United States, to claim that success for women's freedom means that the government guarantees child-free sexual relationships. This has really fueled the current furor over the regulation in the Hobby Lobby decision. The federal government, in all of its documents in this case, specifically tied women's possibility for economic success and equality in the culture with the government forcing private actors to give them free birth control. And they said anyone who did not wish to provide free birth control or early abortifacients was an enemy of women's economic equality. And that was how the debate is squarely framed, and it continues to be framed that way. Turning to another reason for a notable increase in the conflicts that we're seeing, I would point to some of what we might call the outstanding traits of the modern woman or man as observed by sociologists or philosophers or anthropologists. One is our tendency to identify human progress with technological sophistication, including technological domination over nature, even life or death. By definition, whatever stands in the way of what is technologically possible then is obstructing progress. So conscientious objection to everything from embryonic stem research to new reproductive technologies to assisted suicide to new weapons to genetically engineered people or crops can, from this perspective on technology as progress, appear retrograde or even morally suspect. Another modern trait, I would say, is individualism. Now, this could cut two ways, right? It could result in the celebration of the woman or man who wants to operate according to their own conscientious lights. But it is often used instead as the premise for limiting or abolishing conscience rights. For example, burqa wearing, right, is opposed in the name of women's individual freedom. Homeschooling will be opposed in the name of the freedom of the individual child to be exposed to a wider society and school. So this individualism trait has been playing both ways in this debate. Materialism is certainly another strong modern trait. The celebration of economic gain and social status, as distinguished from gaining riches, if you will, by family life or social service. The celebration of physical beauty as distinguished from personal relationships or certain kinds of virtue and so on. This factor is another huge factor in the United States debate over this federal regulation that was involved in the Hobby Lobby debate. Because again, the government is claiming that women's financial success hinges on free birth control being provided by their employers. It's also a huge factor in the assisted suicide debate, as the decline of physical or mental health is the premise on which assisted suicide is often promoted. Another modern trait, for sure, is the decline in religious affiliation or attendance. And by the way, as anyone, there's a book out on this by Frank Newport, who was the Gallup pollster's chief pollster on religion, who points out that actually the way that they've been polling on religion, they used to ask, people in person, and now they do it with an anonymous survey, may actually indicate that the decline in religious affiliation is actually not as steep as people say it is. People didn't want to admit in the past that they were not religious. Now they freely admit it to a computer, to a private survey. And now it's just become much more acceptable in many countries around the world. But in any event, if it is the case, and it probably is, that we still have fewer religious adherents today, this means there's simply less sympathy for religious demands to be protected from generally applicable laws. Not only are religious values less widely shared, but non-religious citizens wouldn't understand some of the discrete behaviors that religious conscientious objectors are asking for. They would seem like sort of odd, discrete things that they're doing, as opposed to a well-understood aspect of a fully integrated religious life. A third reason for, I think, the notable increase in conflicts between conscience and other asserted goods is the rapid growth, and the Deputy Prime Minister referred to this in his introduction, the rapid growth of certain beliefs about religion and religious people. There's a belief that religious believers are just irrational, They rely on ancient texts and ideas that have long been overtaken by science. There is a belief that religious believers claim to know objective reality are just darned annoying. I mean, who knows the truth? I mean, science is always still investigating. Who are these people who say that you can know truth for sure? There's also a belief that religious actors are hypocrites. They craft these demanding standards for everyone and then they violate them. And I can tell you as a person who worked on investigating clerical sex abuse within the Catholic Church, that this is a gigantic reason why people do not wish to give religious exemptions, right? Or if you look at luxury spending on church properties, people think to themselves, why would we want to give a group like that any special favors at all? And then, finally, there's the related notion, in some cases, that religious folks are prone to terrorism or violence because their beliefs are of the ultimate, God said so, therefore I must variety. This notion gives rise to the conclusion that public safety requires a really tight rein on religious tendencies. This summary of the reasons for the current clash lets you think about mitigating it, I hope, in ways that maybe you hadn't thought of before. The ways that are prior to the big question, how much room should a society allow for religious freedom or for conscience protection generally? You could think or rethink about our modern commitments to materialism or individualism or equating progress with technological progress. Maybe you just want to curb the regulatory state as a general matter. Maybe you think it would be very helpful to learn more about the fully integrated lives of people with certain philosophical or religious commitments. You could demand, maybe, that people who are seeking conscientious objections prove their sincerity, or even better, provide reasoned evidence that their freedom won't unleash chaos or might be beneficial to the common good. You could do all these things. I think, though, on top of that, we shouldn't stop there, that we should also consider the possibility that freedom of conscience is a substantive good in itself. And I want to turn now to thinking about some of those possible reasons. My first set of considerations specifically addresses some of the misgivings about people of conscience I mentioned above, whereas the second are some recently and some perennially expressed ideas about why freedom of conscience is good for a society. So first, about our misgivings about allowing it. The first, the fear of chaos or anarchy, right, if we permit too much conscientious protection. This fear, I think, is probably not terribly well-founded in your national situation or mine. Our legal and also our informal processes, sorting things out in the media, in civil society, these processes for hearing out the various interest groups in a particular conflict and for coming to some judgment are rather developed. The government and various interest groups are provided ample opportunity to make the case that their interests are very important and maybe even overriding. The government has the option and the venues for demonstrating that their interests sometimes are compelling to the point that conscience simply must stand down in certain circumstances. Further, in both our nations, we've demonstrated our capacity to make complex regulations in many areas, environmental, energy, fishing, wildlife preservation, etc., tailored to the specific needs and goods of a lot of diverse people. We've done the same in the past, respecting myriad sensitive area where conscience is a factor. For instance, thinking about conscientious objection to military service, using illegal substances in religious services, protecting the seal of confession in the Catholic Church, hiring and firing ministerial personnel within churches despite employment discrimination laws. This is not to say there never arises a genuinely complex conflict between the state and society or a conscientious actor here, but only to say that we've pretty much shown ourselves capable of managing a lot of complexity without descending into anarchy. What about the fear that deep conscientious convictions, particularly religious ones, are irrational? This is a very big topic on which I have spent a large part of my writing, particularly in the family law arena, where if you actually care to read any of my articles, they consist of about 20% numbers and about 50% footnotes with sources, with data. So I have attended to this, but I could only deal with it briefly here. First, many religions, and I'll point to Christianity in particular, regard the interplay of reason and faith to be an essential aspect of their faith. If you actually take the time to read their theology and also their various public statements on matters that come before a legislature, you're going to see that Christian arguments, I should say, are using sources mostly derived from reason. They also, in addition to citing various kinds of scientific sources, give evidence of the invaluable kinds of knowledge that comes from being, worldwide, the single largest private provider of social services to vulnerable people. And since vulnerable people don't get to speak up for themselves quite as often, they really aren't invited all the time to give testimony before legislatures, they don't make the front page of the newspaper in the lead paragraph that often, this kind of testimony that religions give because of their intersection with vulnerable people, their close-up caring for them, is actually not only irrational, it's irreplaceable. Not irrational, but it's irreplaceable. And even respecting religions who make less of a big deal about their absolute dependence upon the interplay of faith and reason, if you actually look at the documents that they are putting forward on a variety of issues of great public neuralgia, they really tend to use rational arguments in many, many cases. And it's worthwhile taking the time to look. I'm going to add here that I find, definitely in the United States, that the groups most strenuously raising the specter of irrationality by conscientious, particularly religious actors, are themselves often operating from an ideological and at least not attempted to be rational platform. I had an experience of this a couple months ago before the Supreme Court handed down the Hobby Lobby decision. I wrote this gigantic law review article that looked at all the government's data. The Institute of Medicine report they used for the rule, and then every time they made reference to the scientific rationale for the rule in any of their briefs, I think there were, 300 plaintiffs in 93 cases the government is fighting on just this narrow rule. And what I discovered was that they didn't have a single piece of data that drew a causal correlation between free birth control and improved health for women for a variety of reasons, one of which is that any woman who can't afford birth control in the United States already has it free. She not only has it free if she's at or below the poverty line, but she has it free if she's 2 or 3 or 400% times the poverty line. Birth control is just a wash in society, and then also we had the fact that 99% of sexually active women were using it, and 90% of companies were already providing it at very low cost or free. So, and then all the arguments about causal relationship between a pregnancy that was not desired and the woman's health, none of those arguments were causally based empirical science. Basically what they said was that the woman who was most at risk for unintended pregnancy was also a woman who was also going to be in the category of more likely to have domestic violence or to smoke or to drink. The government was claiming that a lack of birth control was causing her to smoke and drink and get beat up. But the studies they cited said the causation was the other way around. So anyway, I make this empirical argument, I expose my data, and the attorney on the other side, who was representing Planned Parenthood in an amicus brief before the Supreme Court, got up in front of the students at the law school and says, Professor Alvaré is really just imposing her moral viewpoint on you. And I thought, where did I do that in the last 70 pages of data? And then her viewpoint was, it's simply the case, everybody knows it, it's common sense, what she's saying makes no sense, and do not look behind the curtain, I am correct. It frankly is very typical of the arguments that we get into in some of these more fraught matters. Furthermore, groups calling any comprehensive worldview irrational and suspect often will try then to label their own perspective as purely secular, purely empirical or rational, but then they refuse to engage not only the data, but the possibility that their secularism itself is a kind of comprehensive worldview, whether materialist or scientist or individualist, but actually quite comprehensive. So the idea that each of us does not have positions we start with is usually false. What we really need to do is admit that to everybody. Here's where our presumptions are. Ask the listeners which one of these better accounts for the world as you see it. We both have an anthropology or a presumption on our side. And then use data when available, and then let the listeners evaluate whether these arguments are better accounting for the world as they see it, are more rational, one or the other, as opposed to trying to just say that anyone operating from a comprehensive worldview, particularly religious, is per se irrational. Now I want to turn to some arguments for making room for religious freedom as a social good, okay? The first argument is quite old, but I think it really resonates still. It's the reminder that human happiness and freedom still depend upon people being able to search for ultimate meaning and then to live their life in accordance with what they find. There's interesting neurological evidence of this, that people are kind of hardwired to seek meaning. There's, of course, global historical evidence of people doing just that. You can really even see it in your own national surveys, which they're not exactly ours in terms of numbers, but they're similar in this way. Even people who decline religious affiliation, you had in 1989 and a 2011 study, Webster, Perry, Vaccarino, Havan, and Gendar, who were the authors of these two studies, show that even those who don't profess to a particular religious affiliation indicate that they have spiritual beliefs that assist them in ordering their day-to-day lives. Further, do we really want to hobble adults' capacity to evaluate things, to decide about right and wrong, to order their lives in accordance? Is this not a basic human task for achieving adult identity? Is it not a basic task for achieving a modern society? A second but related argument states that I think it could be considered objectively unreasonable in light of world history and people's doing this, but also in light of the world as we find it, as a beautiful, mysterious, sometimes terrifying, but perhaps most importantly, a world not made by you and me, not ordered by us, a world in which you and I were not self-made. There's a time when we did not exist, and there is a time when we will no longer exist. In such a world, is it really reasonable to impede or close off ultimate questions, or living in conformity with the answers? Questions like the meaning of my own life, of relationship, about the meaning of our life together in community. There's also the fact that if we don't leave people free to pursue these questions, to judge, to order their lives in integrity, what will be left to supply their system of meaning? The majority view, which has been proved wrong now and again, the predilections of the rich and the powerful, of the government in power? Are we satisfied to leave to the government control over even natural pre-governmental institutions like the family, like worshiping communities? Isn't there a really important sense in which protecting individuals' ability to interact with the infinite and to dialogue there is a crucial protection against tyranny? A third argument for accommodating conscience is emerging from rather interesting new literature. There's an institute that got started at Georgetown University in the United States, and now it's taken on a life of its own. It's called, interestingly enough, not sure this is going to get a lot of Google hits, but religiousfreedomandbusiness.org. Not something you usually think. This institute, led by the research of some very eminent scholars, Daniel Philpott, Brian Grimm, Roger Fink, Tim and Rebecca Shaw, has been demonstrating and even interestingly making causal links between religious freedom and social peace, between religious freedom and women's freedom, between religious freedom and freedom of the press and economic prosperity. There's a great deal of literature on this, as well as literature on the relationship between religious freedom and increased voluntarism in society, volunteer, behaviors, and the good that religious freedom has provided in society in terms of family stability and social cohesion. A fourth argument for conscious accommodation, I think, is the pretty impressive track record that communities of conscience have amassed in certain human rights arenas. Even movements that don't command a lot of people at any given time have gone on to exert corrective influences and sometimes to drag whole countries in the right direction. I am ashamed to say that in the United States, we still have capital punishment. But there's this one fabulous nun, Sister Helen Alvare, and there was a movie made about her, right? I've been privileged to share the stage with her. We're the two Helens, and she's really, really the eminent one. She has really dragged the United States, kicking and screaming, more and more toward the abolition of capital punishment. This one woman, okay? The movement for civil rights, the movement for pacifism. I have a son who I'm pretty sure is a pacifist at the moment, who's been working for the Dorothy Day Catholic Worker House, for any of you who know her work. She worked with the drastically poor and the people who were unemployed during the Depression in the early 20th century. I'm not sure if I'm a pacifist, but I think pacifists ought to have a big voice in society because they have such an important message and will drag us and the debate in a great direction. People in the anti-slavery movement years ago, in the civil rights movements, disability rights, people in movements opposing discrimination against LGBT persons. All of these movements have started super small, but look at how they have dragged societies in the right direction, okay? They have a track record, even really tiny communities of conscience. So at this point, I want to conclude by focusing on the debate over a question about conscience protection in the End-of-Life Choices Bill. The debate is essentially this. Does the bill provide enough protection for conscience when it requires objecting doctors to refer a patient to someone they know will carry out euthanasia, rather than allowing them simply to say, I can't help, and stop there, okay? What can I offer based on some of the principles that I've just set out above here? I would apply maybe some of the following. I would start with the fact that you're talking about a really weighty matter here, right? A matter of life and death. And that the state would be demanding that somebody cooperate in killing, in a matter of killing. Now, the whole question of is referring someone to another doctor a matter of cooperation? We can discuss that further if you'd like during the Q&A. There's a vast amount of both philosophy and theology on things like formal cooperation, material cooperation, remote and imminent, etc. It's in the philosophical, it's in the theological literature of various traditions, but it is most certainly a long discussed and not a new objection to say passing someone on to someone who will definitely do this would violate someone's conscience. There's also the fact that with euthanasia, the state would be demanding cooperation with an action held not too long ago and for a very long time in history to be a crime against human rights. Now and instead, what is a crime would be defined as something of a right to demand assistance to be killed. It is still a hotly contested right, but a right. And objectors would be coerced to cooperate. That's breathtaking change in short order. That's why in the United States, when one Supreme Court decision reversed the law of the 50 states on abortion, there was an immediate conscience protection put in on the understanding that, wow, this is big. Every state's law has been abolished overnight, and we're going to provide conscience protection. And the Supreme Court even mentions it in the United States in its abortion opinion, saying we understand conscience protections will follow. So have things really changed so much in the last 40 years that we wouldn't understand that such a sudden reversal might also do well for civil peace to have a conscience protection? I would also take a very close look in this debate at the relevant empirical evidence. What happens in an environment of legalized euthanasia? The experience in the Netherlands would really have to be consulted. I mean, they really have some of the longest experience in this. It indicates that it's not really patients with uncontrollable pain who are most now patients who are euthanized, but in fact that they are finding that more and different kinds of groups are entering this category. There's more non-voluntary euthanasias. There's a lot of increased use of it among the disabled, the aged, the lonely, and the bereaved. There's an increased use among people with psychiatric, but not with physical ailments. Plus, there has been noted an increase in family pressures associated with euthanasia. So an honest assessment of any law in this area would have to take a look at what empirical data there is, and the Netherlands has some of the most developed on this. Respecting the practice of euthanasia, I would also want to make sure to take the pulse of the not-so-privileged population, right? I don't know the data in New Zealand, but certainly in the United States, euthanasia has the support of those with more money and more education and does not have the support of people with less. Okay, it falls out the same way the abortion debate falls out in the United States, so does the euthanasia debate in the survey evidence. One might also want to take into consideration broader factors, like the track record of communities of conscience who might be objecting to cooperation with euthanasia. In the US, the communities objecting to euthanasia are also the communities who are advocating most strenuously for the rights of the disabled and the imprisoned. Maybe these are people we ought to listen to, if they have this kind of track record. Euthanasia also intersects arguments about the substance of progress. Is it technological, individualistic, materialistic control over human life? The practice of forcing someone to cooperate to take the life of another might be taking one side of this debate, while siding with the conscientious objector represents a critical reception of this notion of modernity or progress. It might even represent, conscientious objection, a very different idea about human progress. One of the most developed places I ever saw this was in Pope Benedict's, I say it was his third encyclical, Spe Salvi, Hope Saves, where he said that what is human progress? It's improving human solidarity, especially with the lonely, the sick, the aged, the disabled, or whoever is the most vulnerable in society. Finally, you might consider the question of conscientious objection with cooperating with euthanasia in the context of some of the larger arguments I made about the good of respecting conscience. Maybe you really like the idea that the free man or woman ought to be able to have and live in accordance with an opinion about ultimate questions, as long as we're really not talking about harming the common good or provoking anarchy. Maybe you like this idea of the individual person against an overweening state or the powers that be. You might also decide, however, that this position renders you happy to affirm simultaneously people's individual right to determine their own meaning, to include determining that they would like to die and to get assistance killing themselves without any legal disabilities for their family or their estate, but that maybe you don't want to enlist other people to be forced to cooperate with this. These are just some of the factors that might be at play in this euthanasia debate. A few final remarks. If you're someone who desires generous conscience protection like me, I think you have to own up to the fact that you're not going to get a very good hearing or have much success unless you better communicate with people what it is that you share with the wider community. What are the goods and goals that you have in common? Maybe you just want to get there in a different way. Right? And maybe you're really going to have to step up to the plate and prove with experiences elsewhere or with reason or with data that your argument will not provoke chaos, anarchy, etc. Now, of course, if you're going to be allowed to get this argument out, this is going to require media and governmental associations and other venues to have to be open to these kind of communications by religious or other conscientious believers. And frankly, in my country, the media is not so open to lengthy publication of these opinions. There are certain groups that can publish at will in any of the major papers, and certain other groups that will find it's going to be a cold day in hell before they ever get an article in that same newspaper. Communities of conscience also will need to demonstrate integrity in their own affairs. They need to be willing to offer evidence that their preferred behavior will contribute to human flourishing. I think, frankly, you cannot, in my view, make an argument for conscience protections in any arena without also arguing that the substance of the thing you want protected is promoting the common good substantively. Otherwise, you just seem to be special pleading. Right? But of course, this requires public and legislative debates genuinely open to reason And frankly, a lot of these debates are conducted strictly according to emotions, memes, and name-calling. So with that, I think I've gone on quite long enough. I hope what I've given you is a broad framework for evaluating the clash between conscience rights and other claimed freedoms and social goods. I'm sure we're going to have more than a few things to chat about in our Q&A, and I thank you so much for your kind attention at this hour of the day. So thank you very much.